Good morning, everybody, and welcome back to the fourth part of this module on FOSS licensing and copyright. This is the last in the series, and I hope with these four videos you have been able to see everything from how FOSS licenses work, how they're used, and in this case how the different legal issues within a project are managed and some of the legal issues that have been faced by FOSS licenses in the courts. So this is in part a summary and overview of the different learning that we have had in the other videos, and also an opening up of this discussion in terms of the legality and validity of FOSS licenses and the challenges they're facing. The first thing we will look at is managing copyright and licensing issues in a project, complying with licenses, dealing with fragmentation, and how to enforce a license if someone is breaching it. And the second part, we will look at the nature and validity of FOSS licenses from a legal point of view, how this has been interpreted and applied in the courts. So the first section, summarizing some of the topics we have seen in the previous videos, looks at managing copyrights. Okay, the main issues of copyright issues in an open source project are the ones identified here: ownership, development, and exploitation. It's absolutely core to manage IPR ownership in a project. This is the basis for copyrights and the basis for licensing. The key issue, obviously, is identifying who owns the rights, and also deciding whether you want to centralize all the rights in a specific person or entity, or whether you want a fragmented copyright ownership like the GNU Linux project. Single ownership has the advantage of a single point of control. This person, if they have 100% of the copyrights, as we saw in the previous video, they can manage the license, change the business model, and act with more flexibility. If there is joint ownership or fragmented ownership, obviously everybody needs to participate in licensing decisions, and this becomes more complex. Some projects require that all the IPRs in any contribution are assigned to the project under a contributory license agreement or other form of assignment. For some community projects, this is not acceptable, and they prefer to contribute their code under the project license and only under the project license. So there's a question of management, of how you manage the IPRs there. And on the other side, obviously, we need to respect the moral rights of authors. And for that, we need to identify those authors. And often projects will have a page with the list of contributors, or sometimes even in the actual source code itself. The second IPR issue, we've seen this before, is to identify what type of work we are creating. Whether this is an original, totally new work where we have freedom for licensing choices, or if this is a derivative work of another, if this is an improvement and extension of a third-party software, or if it uses third-party libraries. And in this case, we need to look at the issues we raised in the previous video regarding license compatibility and compliance. And finally, we need to look downstream, outward-looking. How are we going to use this software? How are we going to disseminate this software? And how are our users going to use the software? Are they going to only use it internally? Are they going to be sharing it with other people? Is it a distributed software in the network, or is it a software as a service hosted on the internet? And this will affect your licensing. For example, if you have a software which is specifically for SaaS, maybe you want to choose a copyleft in the cloud license, like the AGPL, the Affero GPL, because this ensures that the software is available for everybody, even if it's hosted on a server. The second question of license management in a project is a question of compliance, and this is just an introduction because my colleague Marco Cecina will be commenting this in more detail. The most important thing, of course, is to document and to identify and document the use of third-party software. And I've seen projects which have 2 or 3 libraries, and sometimes they have up to 250, or I've seen actually 3,000 different pieces of third-party code, for example, in a large Perl project. So this can be a complete headache and very difficult, but is a very important first step. Second of all, you need to read the license and understand the obligations, and when you do distribute, we need to comply with all these obligations. I will leave this issue for Marco. Thirdly, issue, fragmentation, incompatibility. When we have all these licenses, all these different third-party components, we find that it's a big headache. There are many licenses to manage, and there are licenses which are incompatible. We discussed this in the previous video, and the project managers need to have a means for managing these issues, for understanding, analyzing license incompatibilities, and ensuring the legality of their project. The main issue here is regarding the scope of GPL and how using a GPL library or GPL component will affect the rest of the code. But this also needs to be understood for other copyleft licenses like the Eclipse license or the Mozilla license. Anyway, the important thing here is that the identification of the components will allow us to understand the licensing issues. And the fourth point in terms of managing the licenses is the question of enforcing it. This arises when there is a third party who you believe is infringing your code, who is not using your open source in line with that license. So who can take action? Well, copyright law says that the rights holder in the code is the person entitled to take an action. If it is the authors who still have the rights, then all the authors together, or the single author. And if it is an entity, public entity or private entity, and they have centralized all the copyrights in that entity, then that is the person who can take legal action to ensure. The second point is against who, because sometimes it's very difficult to identify who the infringers are. When something has been distributed on the internet, it can be difficult to follow up exactly and find who the developer or distributor, someone who is making infringement. And we've seen cases where if an infringement has happened, for example, embedded in a software, this software is then used in a hardware device like a modem or other hardware device, and it is the retailer who's had problems using and selling, commercializing the hardware in a market, even if it's not them who's caused the infringement. It's upstream in the supply chain. So, of course, action can be taken against the retailer in the market, but the person who really needs to understand and come into compliance is upstream in the development chain. Third question, obviously, is where to take action. There is law on defining which courts are appropriate for taking legal action, and then that court will decide what is the law applicable. And there are many open source licenses which don't say anything about applicable law, and therefore it is up to the area of international private law which will determine what that law is, whether it is the law of the rights holder, the law of the place where the infringement takes place, or the law of the domicile of the infringer. And this can be quite complicated and also change the balance of the risk of the case. Finally, once you have a decision, if you have a decision, can you enforce it? Again, in the scenario where you are trying to make sure that a product manufacturer is compliant, you can enforce against that manufacturer. But the manufacturer himself would want to ensure that upstream his different suppliers come into compliance, and this can be quite difficult. Finally, we find that in most cases, most enforcement is through amicable online communications, emails from the rights holders to the infringing companies who quickly come into compliance because it's due to mistake or due to misunderstanding. There have been, however, some cases, and I will comment them at the end. So those are the main issues faced by a FOSS project, and these also need to be taken into account when deciding on the license and deciding on to free a software under an open source license, because you'll have to face all these challenges later. When licenses have actually gone to court, or when lawyers have been discussing them, there are some legal issues which have been discussed, and here is what I want to present now. The nature of licenses: are they contracts? Are they mere licenses? Are they valid? how should they be interpreted, which law should apply, and whether the guarantees and the exemption of liabilities are valid and if they can be challenged. The nature of a FOSS license causes problems because mainly due to different jurisdictions. The main question is whether this is a contract. If this is a contract, then contractual interpretation will apply, contractual considerations will apply, and this is very different from just having a mere authorization. Okay, this has implications in terms of whether the contract has been properly formed, and you'll find that some software require you to click on "I accept" when you download or install the software. It has an implication on interpretation, because different courts in different countries have different rules on how to interpret a contract, and the remedies you can get for contractual breach are very different from mere copyright breach. The second question, which is not really a question, is whether the FOSS licenses are valid. And this was in the old days when there was a lot of conflict between proprietary and open source communities. Now it is very clear that open source licenses are valid. This doesn't mean to say that some specific terms may be questioned, but on the whole, there's a whole series of cases in Germany, the USA, Spain, and other countries, in France, where the validity has not been questioned, and the courts have been quite clear in applying the terms of the license to the situation. What they have found is difficulty in interpretation, and this is because many licenses have been drafted, for example, for the US jurisdiction, in terms of publishing software, and this does not really translate into the legal concepts of other jurisdictions, like the EU, where we don't talk about publishing, but we talk about public communication. Also, the terms themselves are not clear and need to be interpreted or applied to each case. Finally, as I already mentioned a little bit earlier, licenses don't specify a specific law like the courts of New York or the courts of Torino for applying a license. So there is a whole body of law called private international law, which helps decide what law and what forum should be appropriate for dealing with this case. And this can be very complicated, in fact, very difficult legal analysis prior to initiating any action or dealing with any infringement. I won't go into the details here, we can discuss it in class, but this is something to be aware of when you are looking at the different licenses. Many European people, for example, chose the original Mozilla public license without realizing that the law and the courts of that license was Santa Clara in California, which was a very inconvenient place to go if they wanted to deal with any issues relating to the license. Finally, there's been a big question about whether the exemption of warranties and of liabilities in all of the open source licenses are valid. Basically, they say that there is no warranty, there are no implied warranties, and if there is any issue, in no event will the provider, which may be the author or the software project, be liable for any damages. Even if they do put the words in red, like to the maximum extent permitted by applicable law, this still could mean that in certain circumstances these exemptions will be invalid. Specifically in the area of consumer contracts, where this type of clause may be considered abusive and unfair, and therefore not acceptable for consumers. There are obviously arguments against this issue of invalidity, especially for professional software, which is used among professionals, but also the fact that the software is licensed for free. So there is no commercial transaction, and therefore you could argue there is no professional or enterprise consumer relationship, but each person is just a licensor or licensee without taking into account commercial considerations. The other fact is that you have access to the source code. So a user can always review or analyze the quality of the code, or they could hire someone to do that for them. So the idea is that the licensee, the user of the software, therefore can analyze the risks and assume that risks, and it is because the software is being provided for free by the software project, therefore there's no reason why they should assume liability. Anyway, this is a case to be discussed. because there is many considerations to take into account. Okay, very briefly, a couple of cases that have come in the courts. The first one was, and the most famous one, was NetFilters against Iptable, where the NetFilters project, Iptable project, against Sitecom. Sitecom was distributing wireless network products, and they were not in compliance with the GPL license in terms of providing the source code of the embedded software and including a copy of the license. This was solved very quickly. In the end, a warning letter was sent. However, the Sitecom did not comply, and they were taken to court in Germany. Sitecom argued that they were not the ones who were breaching, but it was, in the end, the court decided that the authors of NetFilters, Iptables, did have standing to go against the Sitecom company, that the license was valid and binding, that the GPL license were included in the contract, and it was okay to have those terms in English, and that there was a balance. These terms were valid. They were not unbalanced or abusive. There was no hardship for Sitecom. So in the end, Sitecom had to comply with the GPL license, and this was a success for the enforcement of the GPL terms. This has been one of the first cases, and used many times in Germany especially, to enforce this license for other people who are not complying with this issue of complying with the license terms. The other issue was AllNet. Again, AllNet was again a wireless access router and load balancing software hardware product. Again, NetFilter Iptables, again, they were not fulfilling the obligations of the GPL for making the source code available. In the end, the case was settled, and AllNet agreed to adhere to the license and inform all its customers about the rights and obligations under the GPL. Another series of cases has been in the USA between the BusyBox project against various large and small companies. This one, for example, 2007 against Monsoon. Similar infringement, because Monsoon was not including the source code and a copy of the license, and the court decided obviously that Monsoon had to comply with this and make sure that they were in line with the obligations under the GPL. In this case, it was before the New York courts. This was no problem. The court decided there was infringement in New York because the software was distributed there, and the court had jurisdiction or had authority to look at this. Okay. Again, the court ordered the Monsoon to either stop distributing the product or to comply with the license. Okay. And well, in the end, Monsoon agreed to appoint a compliance officer and to publish the source code, obviously, of its version of the BusyBox software, and to make efforts to notify all the existing users of the rights under the GPL code. Okay, this is a positive compliance and enforcement by way of bringing the Monsoon company into the GPL community and making them comply with this code. So, in this last video in this series, what we have seen is issues of management of copyright and licenses inside FOSS project, and how this has been looked at by the courts and the issues raised by the courts. We've looked at issues of ownership and exploitation. We've looked at issues of complying and enforcing the license, and we have seen how this has been looked at by the courts, proving the validity and enforceability of these licenses. This is the end of this series, and I hope you've enjoyed it. After this, you'll be looking at other issues, legal issues relating to FOSS projects, such as patents and trademarks, and compliance and reusability. Thank you very much.